It's Monday. Why doesn't it feel like it's Monday? No, it's a never ending. It's like the never ending story. Oh, isn't that a great movie? Although I will tell you, when I was a little girl and I was watching that movie, I'm like, for the love, please say the name, speak it. And it took him forever. Yeah.
And what is the name?
What is the name?
I had to go back and read it.
Yeah. It's going to come to me because you know my mind is a steel trap.
Moonchild.
No, it's not Moonchild. It's going to come to me. I'll call you at 1 a.m. and say, this is what, thank you. I'll say, this is what he was supposed to say.
Mr. Virgil Ross. Mr. Ross, please state your name for the record.
Virgil James Ross.
Hold on one more. Yes, this is the one.
He had 2 cases.
Oh, he's got 2.
I didn't realize that. So this is not the one that he adjourned. That one did get adjourned.
Oh, that other one got adjourned. This is okay. I was not aware of that. Okay. All right. What are we doing in this case of his?
Your Honor, before we get started, I believe Mr. Ross would like to address the court.
Mr. Ross.
Yes, Your Honor, there's a breakdown in communication between me and my current counsel, as well as the public defender office. At my arraignment, I was denied bond. The arraignment was for an alleged bank robbery charge, and the public defender used MCR 6-106B to deny me bond. Based on his rules stating that I've been convicted of...
that the public defender did that?
Yes, and not Mr. Lauren Brown, but the public defender's office, that the public defender that was assigned to me did that. And based on that...
Denied you bond?
The magistrate denied bond after they used the Michigan court rules, sir. Okay, so after that happened, stating that I've been convicted of 2 or more violent felonies in 15 years, and this was not true. The public defender failed to just simply look on MDOC Otis and seeing that I only had 1 violent crime. Also, with my current and present counsel, I haven't been able to put any input or insist in my own defense. I've requested motions for discovery and full disclosure, and as well as the custody order, and neither one of these motions are privileged. Also, I've asked for any type of paperwork concerning my case, and just until 36 hours ago, I was just notified that the 3rd-degree home invasion charge was changed to B&E. That's part of the breakdown in the communication.
I don't know that, sir. Go ahead. I'll let you finish.
Yes, and I understand and comprehend that I'm not entitled to have the attorney of my choice, but also I'm unfortunately indigent and I can't afford to retain counsel. But the Michigan Constitution, United States Constitution said I have a due process right to have assistance of counsel. So I believe that there's good cause that exists where there's clearly a difference of opinion between me and my current attorney. I believe that I should have. And
so your current attorney, the one with the law degree, you have a difference of opinion. Yes. I just want to get this right. Oh, yes, okay. Sir. Go ahead. Yes. Go ahead then.
And, I mean, the difference of opinion is I believe that I should be able to assist my counsel in my own defense. And even though it's early, I believe that this agreement has caused a fundamental trial tactic as well as a meaningful defense that in the near future. And I'm just respectfully asking that my current counsel be replaced immediately.
Did your current counsel be what?
Replaced immediately.
Yeah, okay.
Oh, jeez. Hey, shut my mouth.
What date did we set that one?
Your Honor.
I sent you a letter requesting this.
22nd? Okay. Yeah, Mr. Brown, go ahead if you want to respond before I do. I just want to, I don't know if Mr. Ross even knows this. He's got another case before me that your counsel's filed a motion to protect your interest in the case. And the court has already gotten a prosecutor's response and we've set it for hearing. So that's interesting, these people not working for you. But go ahead, Mr. Brown, go ahead.
They're not working. I didn't say they wasn't working.
You know what? You know what? I didn't say you. I said Mr. Brown can go ahead. Mr. Brown.
Thank you, Your Honor. Your Honor, the court should be aware that we put several man hours into this. We've had investigators going across downtown Ann Arbor seeking evidence and information on this case. I've spoken with Mr. Ross several times, twice visited him, spoken to him by phone, and spoken to him with a video conference. Mr. Ross believes that he cannot work with our office, and his belief is affecting our ability to be able to work for him in a zealous manner. So we are working for Mr. Ross. He doesn't believe that's the case, but I think that belief is the real thing here. That's going to cause a problem with our continuing to be able to zealously represent him, as he feels that his opinion on how things should be done is, if not superior, at least equal to ours. So that's all I'm going to say on it.
Mr. Ross, anything else you want to say?
Yes, I just believe that there's no transparency between me and my attorney. I believe that I should have my discovery. I believe I should have my police reports. I have none of these things. And I've been in this county jail for 5 months. Also, I should have been notified earlier of the charge being changed from a home invasion to a 3rd degree. So that in itself,
Well, I don't know why you're in. Why were you in there 5 months?
I said 5 weeks, sir.
You were 5 weeks. Okay.
I haven't got not one piece of paper from the public defender's office concerning either charge.
So let's see. I don't have his bond as denied in this case. Is it the other case that it's denied?
In the bank robbery, yes.
Yeah, that's not before me today.
Yes, it is, sir. How is not? I got 2 cases.
Why? What? Hold on a minute. You're going to tell your attorney what to do, and then you're going to tell me what to do.
I'm not telling nobody.
Or what I have.
You should have 2 cases. You have
Listen to me. That case, your counsel filed a motion to protect your interests. I just said it to you. The problem that you're having is you're not listening. Mr. Brown filed a very detailed motion with this court that this court reviewed, requested a response from the prosecutor. The prosecutor filed their response. This court immediately set that case because of partially the bond and the issue that Mr. Brown brought before the court. I set that case for hearing. What date was?
The 22nd.
The 22nd at 2 p.m. So, sir, no, that case is not before me today.
So, Your Honor, what I'm saying
Are we
is I have any of
understood?
this information. I don't know any of this. I haven't seen the motion.
Well, now you do.
It's horrible.
Here's what we'll do. We'll just make this easy for everybody. What time is that other one set?
2 p.m.
2 p.m. All right. Court is going to find good cause to adjourn the probable cause conference in this manner. I will adjourn it 1 week out so that both of his cases can go together and he can still have his complaint, I guess, that he has. And maybe if he'd listened to his attorneys, he won't have the complaint. But I'll let him do what he's going to do. I'll adjourn it to June 22nd, 2023, 9 a.m. Motion. All right. See? Okay, why don't we do this? If he wants to play it that way, we'll just make both those hearings in person. Because if he wants to play that way, Mr. Brown, what do you want me to do with that?
Your Honor, I will leave this completely in the court's discretion. Absolutely.
Okay, let's bring him up. I'll set that in person. That's at 2 p.m. on the 22nd, and we'll see how he wants to act that day. His request for withdrawal of counsel denied. Bond continued. Thank you. Now you're done and can leave. Court calls the case. People versus Maurice Robinson.
Cora Willenbring on behalf of the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Robinson. Mr. Robinson, would you please state your name for the record?
Maurice Robinson.
You got something to say, Mr. Robinson? No, I'm kidding. I'm just messing with you.
No,
Go ahead.
I'm certain that Mr. Robinson has nothing to say right now. Isn't that correct, sir?
All right. Very good.
will see you.